Good morning, everyone. This is George Spees for the Pennsylvania Office of Open Records. Welcome to this morning's webinar where we're going to be talking about basics of the right to know law. A couple preliminaries before we get started. First is that if you've never participated in one of these webinars before, it's essentially a PowerPoint presentation with me talking in the background. The PowerPoints that we use for these webinars and all the PowerPoints for our training, you can find on our website. The address is on the screen right now. You would go to the training tab, scroll down, and you'll find everything there. Feel free to download those or view those as you desire. It may be that you have a colleague who wasn't able to attend this morning, and you can refer them to the PowerPoint. You might want it just for your own future reference, or maybe you're even doing a localized training with your municipality or advocacy group, and the PowerPoint would be of assistance. You're welcome to it. This webinar is also being recorded. And the way it works is that I'm recording it right now using the Teams platform. Within a few days, the administrative staff here will download that to our YouTube channel. And then there will be a link again from the OOR's website to the YouTube channel. So again, if you would like to view that at a later date, a colleague who couldn't be with you here this morning, or like I said, you're doing your own localized training, the YouTube video is available for your use. And we regard it as a public record, so you're more than welcome to use it as you see fit. Questions. I do my best to answer your questions as we're going through the presentation. We have the chat feature enabled. So what you would do is go over there and type in your question. It'll pop up on my screen, and I'll do my best to answer it as we're going through live. Two conditions, however. First is that we're talking about the right to know law, so your questions need to be on topic. Secondly, is I would ask that you try to keep your questions as short and concise as possible. It's just awkward for me to sit here, have to read through several paragraphs that someone may have typed in while everyone else is waiting patiently. Look, if you have a situation that is unusually complex or unique to your municipality, we'll do one of two things. We'll wait until the end of the presentation and I'll come back to it, or we'll take the conversation offline. Again, on the screen right now is the contact information for the Office of Open Records. When you reach out to us, either using email or calling in directly, the administrative staff gets the call. They're very well versed on the law, and they're usually able to help you out. If it looks like something that they can't address, your call will be escalated up to senior management. And there we do our best to get back to you within 24 hours, because we figure, if you're contacting us, there's a good chance it's important and it's time sensitive due to all the deadlines built into the right to know law that we'll be talking about this morning. Okay, so I think that takes care of all the preliminaries. Let's go ahead and dive into the topic itself. Let's talk about, what's the right to know law all about and why is it important? Well, in Pennsylvania, it's the premier law for guaranteeing access, ensuring government transparency, and in essence, good government. But the law itself, we need to discuss what the purpose of the law is. And I refer to this fundamental statement. And the purpose of Pennsylvania's right to know law is to give the public access to public records. Okay, seems rather obvious. Why would I highlight that? Well, oftentimes there is a misunderstanding as to what the right to know law is. People see that term right to know, and they envision the law as some form of Google, where they would type in questions or submit questions to their local government or state government. And they believe then that the government has an obligation to run around and search for the answer to those questions. That's not the case. Also, on the agency side, quite often, the request that you receive may not be as clear as you like, or it's possible that you're just getting confused with the records that you're dealing with, what you can release, what you can't release, what your obligations are, and so forth. So I always recommend to folks go back to this fundamental statement, because this can oftentimes get you steered back on track, headed in the right direction. The purpose of the law is to give public access to public records. No more, no less. Now, there are some presumptions in the law that we need to understand clearly. The first is that the starting point is that every record that an agency has in its possession is presumed to be public. All right, everything you have is a public record, unless the agency can meet its burden to prove that a record is not public. Okay, so the burden is on the agency, not the citizens, to prove that a record is not public. That's not phrased correctly. The citizens bear no burden to prove that a record is public. Rather, the agency, and when I say agency, I'm talking about the Commonwealth, cities, boroughs, townships, authorities, school districts. As such, an extension of school districts would be charter schools, that if they are subject to the right to know law, that when they receive a right to know request, they bear the burden to prove that the record is not public if they're concerned about releasing it. Okay, pardon me. So for someone working on the agency side who first encounters this, who, maybe they first get familiar with the right to know law, or they receive their first right to know request, and they suddenly hear this, the response can sometimes be sheer panic. It's like, oh my gosh, everything in the office is going to end up on someone's Facebook page tomorrow, or, heaven forbid, on the front page of the newspaper. And I'm here to tell you that that's not the case, okay? If you receive a right to know request and it raises a red flag and you're thinking, I'm not sure, I'm not comfortable with the idea of releasing this record into the public domain, there is a very good chance that there would be a provision within the right to know law, or possibly another law, that would deem those records as confidential and would allow you to withhold them and thus meet your legal burden. And that's what we're going to talk about as part of the first portion of this morning's webinar. So it's critical to understand these facets of the law. First offhand, its purpose: public access to public records. Every record is presumed to be public, but if it's not public, the agency needs to prove it's so. All right, so let's move on and talk about the fact that the right to know law is not a confidentiality law. Okay, what do I mean by that? Well, there's nothing in the right to know law that prevents an agency from giving out public records. Okay, let me put an example on the table here. Let's say that it's budget season and that the agency has a stack of budgets. And I come walking in to, I don't know, Borough Hall as a citizen, and I ask for a copy of the budget. Nothing in the right to know law, or any other law for that matter, prevents you from handing me a copy of the budget, and I walk out the door. Okay, it's that simple. Now, let's change this example. Let's say that I have a right to know request, and that right to know request is for a copy of the budget. Again, the agency open records officer, who we'll talk about here shortly, can simply hand me a copy of the budget and say, do you mind tearing up that right to know request? Because that would save you a lot of time and it would save me a lot of paperwork. Why wouldn't I do that? Because I'm getting what I'm asking for, a copy of the budget. Okay, and you're not doing anything improper, unethical, or illegal by asking me to withdraw my right to know request. You can simply give me a copy of the budget, and the right to know law has no prohibition for you doing that. Furthermore, and we'll talk about this shortly, there are provisions within the right to know law that define confidential records. However, the right to know law is discretionary in the agency's ability to release those records, even though they're clearly defined by what's known as an exemption. So if you read a portion of the right to know law that says um, these records can be withheld, the key phrase is can be withheld. It doesn't say must be withheld. Okay. And you need to understand that provision within the right to know law that it is discretionary. And you'll find all throughout the right to know law that it gives agencies a great deal of flexibility in how they manage their open records programs. Now, what we recommend is that for those records that are clearly public and readily accessible, be proactive about it. You have websites, you have other social media platforms. Use those platforms as business platforms, okay? Look at your right to know requests, identify trends. What are people seeking? And put those on your websites ahead of time. That way, the next time you receive a right to know request for one of those records, your response can be, that record is on our website. Here's the link to it. And there is a provision within the right to know law that allows you to do that. So what we're finding as a best practice is that local agencies in particular, they're putting their budgets on their websites. They're putting contracts out there. Salary information for public employees is clearly public information. So they're putting salary information on the websites. Purchasing documents, what's the borough buying? What's the township purchasing these days? Okay. Those purchasing records are on the websites. Okay. What you'll find is two things. First offhand, the hits on your website will start going up because it's it's part of the culture today that members of the public prefer to sit in the comfort of their office or their family room, whatever, and search your website for the records that they need, as opposed to conceivably taking an afternoon off from work, coming down to your building, filing a right to know request, and conceivably waiting up until 35 days until they get a response to that request. And even then, they may not get the records that they're looking for. So that's the first thing. The second thing, and what might be more interesting for those folks joining us today from agencies, is that right to know requests will go down because the information is already out there in the public domain. And like I said, if you receive a right to know request for a record that's already on your website, your response is quite easily, we're granting your request. That record is already on our website. Here's how you get to our website. And it's done. Okay. And like I said, this is what the public expects nowadays. More and more work is being done online. And there's no reason, for the most part, why local government can't adopt that model as well. Okay. So it's something for you to consider, something that we would recommend. But I should emphasize, there's nothing in the right to know law, for the most part, that mandates you have to have a website and that you have to have certain public records on that website. There have been proposals to do so, but nothing like that has become law. Okay, moving on. Let's talk about agency obligations. Your city, your township, your borough, school district, whatever, is subject to the right to know law. So there are some things that you have to do. The first and probably most important is to appoint an agency open records officer, or who we call an ARO. This person does not have to be at any particular organizational level within the municipality. It could be the mayor, it could be the president of council, It could be the nice lady you meet when you walk in the front door of the school administration building. Um, there is no limit as to the number of arrows you have. You could have one borough with one arrow responsible for soup to nuts, any right to know request that's received. You go 5 miles down the road to the next borough, and they may have two arrows, one covering the administrative side, a second handling just the police department. But it needs to be clear to the public, looking at it from their perspective. I have this right to know request. Who should I give it to? Okay. You need to educate the public on how the process works, in particular, who the arrows are, because that's the person legally responsible for receiving the request, processing the request, and responding to the request. So it's an important role within your municipality. Agencies can come up with their own local rules and procedures for how they run their right to know process, as long as it's not in conflict with the law or any rules that the Office of Open Records has promulgated. I'll give you a quick example. Within the right to know law, and I'm paraphrasing here, but it basically says that an agency can, the agency may entertain requests that are anonymous. Okay, the agency may respond to anonymous requests. Well, there's another law in Pennsylvania known as the Statutory Construction Act that defines how certain words are to be interpreted. Because the right to know law has that word may in there, it also means may not. So applying these two different laws, it means that an agency can decide not to accept right to know requests that are anonymous. It can require that a person identify themselves when they submit a right to know request. And like I said, there's provisions like this all throughout the right to know law. So if you have a provision like this, you can adopt it, and as long as it is applied equitably and consistently in a non-discretionary manner, you're on solid ground. You can do that. Okay, that's just one example. You can come up with your own form, and most agencies do. They like to have their seal at the top. Contact information for their arrows. Maybe they list some of those local practices and regulations that they have. But you must also accept the state form, which can be found on our website. There's nothing particularly unique about it. Many agencies will simply link to the state form, and that's fine. And then finally, we ask that you provide us, the Office of Open Records, with the names and contact information for your arrows. Reason being is that on our website, we have a database of arrows statewide. And some of that information is pulled from the Department of Community and Economic Development, but we also rely voluntarily on agencies to keep that data current. And there are a number of reasons. Some folks will contact us and say, hey, I was on the township's website. I couldn't find any information about right to know. I need to know who their contact person is. So we will steer them to our website, and here's the Arrow database. Go ahead and search. Hopefully the information will come up. But we also realize that, there's turnover. People leave, they get promoted, they retire, whatever. So we ask that agencies periodically review our database, make sure the information is current. And if not, there's a form there that can be filled out. You email it to us, we verify it, and then we update the database accordingly so that your municipality's information is current. Finally, if an appeal is filed against your organization, our point of contact is whoever you have listed on the database. So it's important, really important, that that be kept current for that purpose as well. So maybe one of the takeaways from this morning, if you're here joining us from an agency, is take some time out, check the database, make sure that your information is current. And if not, get in touch with us and we'll make sure that that's all taken care of. All right. You're also required to have postings. Now, you're not required to have a website, but if you do, you need to have postings there as well, physically within your offices and on your website, provided you have one. And the same requirements exist. You need to have contact information for the agency open records officer. Look at this from the public's perspective. This is a process with government. I need a record. And the easier it is for them, the easier it will be for the arrow. Okay, so the more information you can put out there, the better. Who's the arrow? How do I get a hold of them? Then what if the agency denies my request? What's my recourse? Well, I do have the right to appeal, and that information should be as part of your posting. Then you would have a form available for them to fill out if they don't happen to have one. The form would be on your website as well as within the physical offices that you could provide them. And then any of those local regulations or policies that you may have promulgated. You want the person to know what the rules of the game are before they enter the playing field so that it's as easy as possible for them. No surprises, because then it will be easy for you in helping them to get the records that they're seeking. Okay, if you have multiple websites, Facebook, Twitter, website page, do you have to do the posting on each or only one? Walt, that's a great question. Your website, a clear reading of the law, you would then say it has to be on your website. Now, if you're using something like Facebook as your main social media platform and you don't have a website, then you'd have to, accommodate right to know on your Facebook page in some way. But, if you have multiple platforms, we're going to be looking at your website when it comes to right to know. Great question. Keep them coming, folks. Okay, moving on. What can't you do with the right to know law? Well, first, you can't limit the number of requests or number of records that a person asks for within a specified time frame. You can't say, ma'am, I'm sorry, you've already submitted 3 requests this week. That's all we're going to allow. If she's inclined to submit a dozen requests in a week's time, she's allowed to do that. Also, you can't you can't compel a person to tell you why they are filing a right to know request. You cannot deny a request based on the reason or what you think that reason is, even if it's just to see you work harder. Now, let me get on my soapbox for a moment here. The greater majority of right to know requests are submitted by requesters for legitimate reasons. You have a record, or they think you have a record that they need in order to solve some problem that they have. However, I'm also cognizant that there are a handful of people out there who have weaponized the right to know law because for whatever reason, the relationship between the agency and that person is broken down. And among a number of things that they're doing, they're also going to file frivolous right to know requests. There are ways that you can deal with that. My recommendation would be to sit in on the webinar that we do periodically on the payment side of the right to know law. Okay. A lot of people aren't aware of what agencies can do when it comes to assessing charges for right to know requests. The greater majority of people are willing to pay a nominal fee in order to get the records that they're seeking. People who have weaponized the right to know law usually aren't willing to pay to be a pain in the neck. All right. And that's all I'm going to say about it, because we could spend, an hour like we do on this other webinar discussing this. Also, if you have a problem requester, you can reach out to the office and we'll do our best to help you out with that particular situation as well. Okay, back on script. off my soapbox. Let's move on here. First, let me get a sip of water. Okay, question has popped up before I move on here. If you don't charge one person, you can't charge another one for the same records, correct? Yeah, that's correct. Whatever practices or policies you adopt as a municipality or authority or school district for that matter, you've got to be consistent and you've got to be equitable uh, in how you apply those rules. Okay, and again, another good question. Okay, I like to describe the right to know process as an obstacle course. Okay, I think it creates an effective picture. Um, you have the start, which for our purposes is when you receive a request. Within the law, there are deadlines. And if you're familiar with competition at all, especially at a high level, there are things called time standards, which basically, if you want to participate, you've got to be at a certain level. Okay, we don't just allow anybody to enter our races. On this obstacle course, there are two hurdles. And in front of the second hurdle, there are three hoops that you have to jump through before you can even make it over the second hurdle. So let's talk about what this obstacle course looks like and how it works. The start, receiving a request. Okay. The law says that upon receipt of a request, the arrow shall note the date of the receipt on the written request. Okay, why is this important? Because immediately a 5 business day deadline kicks in which the agency must respond, provide an initial response to the request. Now, it's 5 of the agency's business days. Why do I emphasize that? Because not all agencies operate on a Monday through Friday schedule. There are some municipalities, in particular up in the northern tier of Pennsylvania, that may only be open 2 days a week. Okay, so how would the 5 business days be calculated? If you receive a right to know request today, well, first offhand, today would not be considered a business day. Let's say you're only open Monday through Tuesday, Monday and Tuesday. So today would not be considered a business day. You'd go to next week, Monday, Tuesday. You'd go to the third week, Monday, Tuesday. You'd go to the fourth week, close of business, Monday would be your first deadline for the 5 of your business days. Police departments, okay, they're a 24/7 operation. We would look at when is the operation accessible to the public for administrative business. Okay, usually that's Monday through Friday. A holiday would not be considered a business day if you're not open for business. Snow emergency, okay, if the administrative side of the operation is closed, that's not considered a business day. School districts during summer break, a lot of times they're not on a full 5-day schedule, so their business days would be modified. I once had a situation where someone submitted a right to know request on December 16th to the University of Indiana, Pennsylvania. Okay, well, it so happened they closed for winter break on the 17th. So, and they didn't open until I think it was like January 20th. So for over a month, they did not have a business day. You just have to take a look at the organization's operation, and hopefully everyone is on the same page as to what constitutes a business day. Okay, but like I said, this is your start, and you need to calculate the 5 business days, at which point you're required to provide at least an initial response. Now, the question always comes up. Oh, another question. Okay, I should have expected this. If the open records officer is only in 1 day a week, but the agency is open 5 days, which would it be? I'm going to say definitively, I don't know because this has never been litigated. However, there is a Commonwealth Court decision. It's called Donahue versus the Office of the Governor, where the court says that the clock starts ticking when the request is received by the agency open records officer. So your first business day would be when the agency open records officer is in the office. Now, how it's calculated from that point on, I don't know. Like I said, it's never been litigated. My suggestion would be to keep on doing what you're doing, and that if someone takes exception to it and the deadline that you're following, they have the right to follow an appeal or to file an appeal. The appeals officer will take a crack at it. And again, if there's no agreement with what the appeals officer decides, there are further steps to the appeal process to the point where we get to the courts and they will issue, their legal opinion, and we take it from there. We would rely on the court's guidance, just like we do with Donahue versus the Office of the Governor. Okay, I wish I could give you a more definitive answer. And it's interesting because this has come up twice now in the last month, and that's the best I can do for you. It's when the request is received by the agency open records officer, how it's dealt with from that point on. I just can't give you a definitive answer. Okay, but it is a good question, and one of these days we'll probably get a court decision on that. Okay, now the question comes up: how long should I hang on to all this right to know paperwork that I have? Well, if you look at the right to know law, it says 30 days, meaning 30 calendar days, or until all appeals have been exhausted. Okay, and there are reasons for that because of the deadlines built into the law. And when we talk about appeals, this can go all the way up to the Supreme Court of Pennsylvania, and that could conceivably take years. So you need to be aware of what an open appeal is, because you want to hang on to everything until that appeal is decided. But there is another law in Pennsylvania. It's called the Pennsylvania Municipal Records Act. This applies to cities, boroughs, and townships. It does not apply to authorities or school districts. Okay, from my experience, there is nothing comparable that applies to school districts. But nevertheless, I recommend that perhaps you want to follow this standard, which is 2 years if you read the Municipal Records Act, which is overseen by the Pennsylvania Historical and Museum Commission Bureau of Archives. Okay, and they have a lot of resources. Okay, the Municipal Records Act basically governs how long municipalities should hang on to every record that they typically come in contact with and would have in their possession. Okay, so I recommend the 2-year standard, or if it's still an active appeal. Okay, just so that you're in compliance with one law. And I think it's reasonable. After 2 years, you do whatever you want. You clean out your files, recycle, shred them, do whatever you typically do with expired records. But I think 2 years is a good standard and not overly burdensome on municipalities to follow that standard. All right. An agency does have the option of an extension if they are unable to provide a response within the 5 business day window. Okay, and it's 30 calendar days. Notice the difference. Okay, now we are talking about Saturdays and Sundays, holidays, emergency weather closings, and the like. Okay, you've got your 5 business days, and then you stack the 30 calendar days onto the end of that. So, we casually refer to it as your 35-day window. But in order for the extension to be valid, the agency must follow certain procedures. First, it must be invoked within the 5 business day window. You can't wait until what would otherwise be the 6th business day, say, oh man, I forgot about this right to know request. Well, we'll just take an extension. Unfortunately, When the 5 business day window has closed, you have denied the request by default. Legally, it's what's known as a deemed denial. Okay, and you no longer would have the ability to invoke your 30 calendar day extension at that point. You need to notify the requester in writing that you're taking the extension. And if they submitted the right to know request by an email, well, you can respond back by email. There's no problem with that. You also need to provide a reason why you're taking the extension. And fortunately, you can go to section 902 of the law and it lists 6 reasons that you just choose the ones that are appropriate. We keep these records off-site, and it's going to take us longer than 5 business days to go dig them out. Or we want our solicitor to review the response to make sure we're not giving out anything we're not supposed to. It's stuff like that. It all makes common sense. Okay, then you need to provide a date for when the person can expect to get their response. Usually it's on the 30th day of the extension. An estimate of any costs they can expect to accrue. And it is just an estimate. It's not a hard quote. You settle up on the exact amount when it comes time to actually provide the records. Now, don't get into the habit of automatically invoking the extension if you don't have to. If a record is readily available and it's clearly a public record, why can't you give it within the 5 business, or why can't you respond within the 5 business days that you're granting the request? Okay, if you don't need to invoke the extension, don't. Okay, but at the same time, we realize that if you're a small municipality and you're only one person deep, or maybe you only have one person at all who wears several hats, then you have to take the extension. You really don't have a choice with some of this stuff. But one of the things that some agencies do, they'll attempt to throw cold water on the right to know process by immediately invoking the extension. And don't do that. It upsets the public, and you don't need any more upset people than you already have. Okay, work with folks and have those discussions. And if you can get your response out within the 5 business day window, please do that. Okay, let's move on. We are on this obstacle course and we're coming up on the first hurdle. In order to make it over this hurdle, we have to answer a question. Is it a record? Okay. Well, fortunately, within the right to know law itself, there is a definition section. And I always tell people that when you encounter a law and you're reading it, if don't forget to read the definition section, because there may be language that is written in legalese, isn't as clear as you would hope. Maybe there's language that at face value is conflicting. If you look at the definition section, oh my. Folks, I don't know if you can hear that, but I'm sitting in 333 Market and there is a fire alarm going off. I'm going to wait until the last absolute second here, and then I have to evacuate and we're going to end the webinar. I apologize, this is out of my control. But if someone puts in a right to know request for a document that you do not currently have but receive monthly, am I able to respond? All right, a couple things here. We just had a drill too. Okay, you're only required to provide a record that you have in your possession. If you don't have that record yet, you go with what you had or didn't have at the time you received the request. So if you don't have the record, you're not required to provide it. You're not required to create a record. You're not required to do any research in order to obtain that record or create it. Okay. How does a new arrow get access to the e-file portal? That would be part of an appeal process. When the appeal is received, the administrative staff here is in touch with you and they provide you with the necessary logon information. Just for your information, usually when we get a fire drill, there's also a recorded voice that tells us to evacuate the building. I'm not hearing that, so I'm just going to sit tight until someone comes in here and tells me I have to leave. I'm sitting in a training room, and maybe they'll forget about me. Okay. Ashley, I hope that answers your question on the e-file bit. Okay. That's something new with our office, and we recommend that you take a look at it. Everyone's walking around wondering what to do because there's no recorded voice telling us to evacuate. Okay. Yeah, Ashley, you would actually, I think the way it works is you actually have to be part of an active appeal. All right, this is really entertaining here. Okay. All right, let's talk about what a record is. Okay. A record is any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, we have the key phrase highlighted, documents a transaction or activity of an agency. What does that mean? Well, it means that the record has to be about the agency and the business that it conducts. Okay, now why wouldn't it be? Well, think about this. Let me give you some examples. Let's say that I'm, one of your employees, and I send an email to one of my colleagues. I hear that a new restaurant's opened up downtown. Let's meet for lunch tomorrow. Or, what do you guys think about the Eagles' season so far and how Jalen Hurts is doing? Do you think they'll make it to the Super Bowl? Or I'm going to pick up a gallon of milk on the way home tonight. Okay, now these are all communications that are fairly common, but none of them have anything to do with the running of our municipality. Thus, they don't rise to the definition of a record, and they would not be subject to a right to know request. They would not be considered responsive records. So I don't have to worry about messages like that, communications like that being released through the right to know process because I don't make it over the hurdle. They're off the course, okay? And they're not considered records. Now, a question has popped up here again. If a posting is put into a newspaper, is the posting in the paper a record? Or is it only a request if submitted by mail or, okay, that's going to depend on the context of the posting. Typically, you could also make the case that that's in the public domain. But if it's a posting, the copy of the posting that the municipality has in its possession, okay, is the one that you would be concerned about. Let me just think about this, and I'm distracted by this stupid siren going off. The law says that the posting would be electronic on the agency's social media platform or website, I think is the term that's used. It does not mention postings in a newspaper. So if someone submits a right to know request for a copy of the posting and the agency has a copy in its possession, good, it's stopped. I think it's just a malfunction. So if the agency has it, and it starts again. So if the agency has it in its possession, then the agency would be responsible for providing it in response to the right to know request. Another question has popped up. Person uses text on their personal phone regarding, yeah, that's the next part that I was getting to, Michael. Okay, the other point that I want to make in response to this slide is that I could be sitting at home on my personal computer on my personal Gmail account. And if I send a work-related email, that is subject to the right to know law. And that would include text messages on my personal phone as well. It's not how the message is created, how the message is sent or how the message is stored. Rather, it's what is the content of the message that determines whether or not it's a record. Now, there is nothing wrong, there's nothing illegal with using a personal device or personal account to send work-related messages. You just need to understand that if you're going to do that, your device and your account could be subject to use your term, discovery under the right to know law. Okay, nothing in the law prevents you from using your device. But one of the very first rulings out of the courts related to the right to know law is that you cannot use personal accounts and personal devices to hide the public's business. My recommendation is don't do it, but that's only a recommendation. It's not a legal opinion. Okay, and it's purely because of the, potential to have someone else looking through your messages to determine whether or not they're responsive under the right to know law. Okay, another good question. Can you guys hear that siren in the background? I'm just curious. No. Okay, well, good for you. It's pretty annoying here. It's pretty loud, but no worries. I'm going to keep going. Okay, let's move on. Okay, so let's presume that it is a record. So we go over that first hurdle. Now we're coming up on the second hurdle, where the question that we need to answer is it a public record? Okay. And like I said, we have these three hoops in front of the hurdle. So now we need to answer a question: are there any exemptions that apply? And if so, are we going to invoke them? The exemptions that I talk about can be found in Section 708B of the Right to Know law. And you can find the law on our website, download it, doesn't cost you a dime. It's not a hard law to understand, okay? It's not that long. For the most part, it's written in English, okay? There is some legalese in it, but for the most part, you can kind of understand it. You go to Section 708B, and there are 30 exemptions, 1 through 30. Each exemption is a group of paragraphs that define a record or a type of record that an agency may withhold from releasing to the public if they want to. Okay, and it covers an incredibly broad spectrum of records, and they are the type that if you were to receive a right to know request, a red flag would kind of go off in your head saying, I'm not sure I should release these. So take a look at the exemptions, and chances are you will find an exemption that applies here. For instance, there's an exemption that says if by releasing a record you would put someone in harm's way, you can withhold that record. There's another one that says you don't have to give out anything that could compromise your computer systems. Or there's one that says you can withhold health records. There's another one that says we don't give out any records related to minors, okay? We don't give out stuff like that. And you can then choose to invoke that exemption. All right, so if there is an exemption and you choose to apply it, you don't make it through the first hoop. You're off the obstacle course. But if there is an exemption and you choose not to invoke it, you're through the hoop. Or if there is no exemption at all, you're through the hoop. Okay, so now we come up on the second hoop, and we have to answer the question, are there any federal or state statutes or a judge's order that make these records non-public? And here you'll find language in the law in Section 306. And what it basically says, and I'm paraphrasing, that if there is another law that deems these records confidential, that trumps the right to know law, okay? And it's particularly important because these laws typically do not have any discretion. Rather than saying you may withhold these, they say you must withhold these records. You are not allowed to release these to the public. In Pennsylvania, there is, for police departments, there is a law called CRIA, the Criminal History Records Information Act, which identifies a body of records that they can only share with other police departments. They can't release them to the public. Okay, and if they were to release them, there would be potential criminal sanctions against whoever released them. Health records. At the federal level, you've got HIPAA, ADA, FMLA, and a host of other alphabet soup laws that say you cannot release health records to the public. You can, you have discretion within the right to know law, but under these federal statutes, that removes the discretion. And like I said, they trump the right to know law. Okay, why is this important? Because let's say you're concerned about releasing a record and you can find nothing about it in the right to know law. You should be familiar with these other laws that demand confidentiality, and you would use that as your legal burden for withholding the laws from public release. You understand how that works? I'm not going to use anything in the right to know law to withhold these records. Rather, I'm going to refer to another law that deems these records as confidential in order to meet my legal burden for withholding them. And then you can tie that back to Section 306 of the Right to Know law, which recognizes the jurisdiction of these other laws and their importance with defining certain records as confidential. So let's say that we can't find another law. Well, then we make it through the second hoop. But now we need to answer the question, is the record protected by privilege? And here we're referring to attorney-client privilege for the most part. Attorney-client privilege protects any communication between an attorney and their client of a sensitive nature. And for our purposes, typically it would be the solicitor and elected officials or senior officials within the municipality. Okay, so any email, any memos, any letters that are sent would be protected by attorney-client privilege, and they would not be public. Okay, and attorney-client privilege is part of the rules of evidence in Pennsylvania, and it's reduced to statute, so you can find it, but it's also referred to in the Right to Know law in Section 305. And we actually do another webinar on laws that protect information. And if you're curious about these other statutes and attorney-client privilege, maybe you want to sit in on that webinar and we'll do our best to explain how that all works. But if it's not protected by attorney-client privilege, then we've made it through the third hoop. And now, okay, hold on. Okay. Apparently it was a fire drill, so I should have evacuated, but now they're saying it's over, and I won't tell if you don't tell. Okay, folks? All right. So if there are no exemptions, if there are no other statutes, and it's not protected by privilege, then we do make it over the second hurdle, and it is a public record at that point. You do respond back that you're granting the request and the records are available. Okay, so let's move on. When we grant a request, we suddenly trigger the payment side of the right to know law. Okay, now there's some important points here that I think you need to understand. First, we find in Section 701 in that the agency is only required to provide the record in its current medium. And again, I'm paraphrasing here. And what does this mean? Well, it's hard copy versus electronic. So if someone submits a right to know request for a record and they're asking that it be sent to them electronically, but the agency only has the record in hard copy, a piece of paper, you are not required to scan that record in because that is converting it from hard copy medium to electronic medium, and you don't have to do that. So your response would be, we have the record, but it's hard copy. We'll provide it to you, but it's going to cost you. Okay. Do you still want us to proceed? And we can take it from there. You cannot charge for electronic records, meaning if someone is asking for emails and you've determined that those emails are a public record, you can't charge for sending them the emails. A person can ask to inspect the originals rather than ask for copies. And if they do that, the agency is in the driver's seat. The agency determines when during normal business hours that the person can come in to inspect the records, and the agency can supervise the inspection. They can have someone present to watch what's going on to make sure no records are altered, stolen, destroyed, whatever. Okay. And the agency cannot assess any fees for labor, redaction, or any sort of legal review that your solicitor may make. These are all just considered the cost of doing government business. So you can only charge what are considered actual costs. I mean, something like postage, okay, there you can document. It's costing us $3.15 to mail this out. So we can put it on the invoice to send to them. Okay, some questions have popped up here real quick. Let me back up on the screen so I can read these. Okay. Regarding law enforcement, Act 17. No prohibition regarding the release of non-criminal investigation into this act. Okay, I'm not familiar with Act 17. Can you still deny a request for body worn? Oh, it's Act 22. It's not Act 17. Yeah, it's Act 17 of 2017. Or no, Act 22 of 2017. You've got the numbers reversed. Okay, body camera footage is governed by Act 22, and that's completely outside of the right to know law. Okay, you need to look at Act 22. Go to the state police's website. You'll find we have a page on our website that covers Act 22, but the Office of Open Records has no involvement with Act 22. Okay, any body camera, dash cam, security camera is governed by Act 22. We actually have another webinar that covers right to know law for law enforcement. We briefly touch on that, but that's all governed outside of the right to know law. Sorry, I can't help you out there. Okay, now moving on. Can a person take photos of documents if they request to view them? Yes, they can, and we have case law to that effect. It's Munz versus, oh gosh, I forget the name of the borough, but the case law is on our website. If a person comes in to inspect public records, they are allowed to take a photograph of those public records unless they're covered by copyright law. That's the only exception. Okay, if the documents are in paper form, can the agency scan them to send electronically and charge per page to do that? No, you cannot, Walt. You can scan them in and send them electronically, but you cannot charge for those electronic copies. Okay. Regarding fees, on the second page of the official right to know fee schedule, additional notes, other statutory fees. Okay, if it is referenced, can be charged statutes outside of right to know. Okay, as far as I know, there is no statute that allows, that governs charges for fire department records. There is, or there, what can I say? The Pennsylvania Motor Vehicle Code covers the release of accident reports. Okay, it allows you to charge for accident reports. Okay, our department normally charges up to $100 for a CD file. However, the fee schedule, yeah, it's $1. Okay, if you cannot point to a statute that allows you to charge what you are for a CD, you are out of compliance with the right to know law. There are electronic records. If I'm assuming they're electronic records, you are charging well above and beyond what the fee schedule allows you to charge for. If you have questions, maybe you want to reach out to our office about that. But I am not aware of any other law that establishes a fee schedule for fire department records. At issue is whether or not you're required to release those records at all, okay, given the content of NIMS reports and so forth. You might want to take a look at whether you're required. The same thing comes up with, we go back to Walt and the question about why can't I charge for records that I need to scan in? And, Section 701 basically says you don't have to scan them in, okay? You only have to charge for paper records. And if that's all you have, then you do not need to scan them in the first place. That's why this provision is particularly important, because there is this misunderstanding that if someone requests electronic records, I have to scan everything in to make them electronic records. This provision of the right to know law basically says you don't have to. Okay. I think we've covered this slide, and I think, you're asking good questions here, so keep them coming. And no doubt we're going to run over our time frame here, but let's move on to, okay, I need to advance this slide, get my cursor over here. Yeah, more payment issues. I've said it before, no surprises. The more information you can put out there about the payment side of the right to know law with no surprises, the better things are going to be. So you receive a right to know request, do a quick estimate, and think, okay, it's going to cost us probably around $30 to get these out. Okay, well, there's nothing preventing you from reaching out to the requester saying, hey, this is going to cost around $30. Are you okay? Do you want us to proceed? Because some people mistakenly think the right to know law is free, and it's not. Okay, we have a fee schedule out there. Now, under the law, it's preferable for a mutual exchange. Here's the money, here's the records, but the law says records are provided upon payment. That means they pay first and then they get the records. And I also need to clarify here that the deadlines we talked about, the 5 business days, the 30 calendar days, they are when the response is due. That's not when the records are provided. Okay, there's nothing in the right to know law that establishes deadlines for providing the records. Those deadlines are for when you provide the response. So it is completely within your rights to say, within 5 business days, we are granting your request and will provide you with the records when you send us a check and the check clears. Okay, and then we'll make arrangements to provide you with the records. Okay, and that could very well be outside the 5 business day or the 30 calendar day deadline. You would, it's subjective, but it's, what would a reasonable person expect? I mean, it's usually a couple day turnaround, okay, but it's the deadlines refer to the date you provide the response, not the date you provide the actual records. And then finally, what if you get a request that's really big, that the response is going to be in excess of $100? Well, the right to know law has this feature where if payment is going to exceed $100, you can demand payment up front before you even begin processing it. I like to refer to it as a security deposit. Okay, it's send us a check for the full amount, and then we'll begin processing it, because that way the agency doesn't get stiffed for doing a lot of work, for making a bunch of copies, and then the person balks at it, and you're left stuck with all this work. Okay, question has popped up. Is there any case law on agencies saying, yes, we will provide documents, and then waiting, let's say 60 days to fill the request? Only under, well, there's no case law, but only under very extenuating, well, yeah, I think there is some case law, but it's the parties, everyone has to agree to it. And it goes back to, let me think here, it's the state system of higher education. And a union. The union is known as ASPUF. It's the professors union. And it was an extremely large request. I mean, thousands and thousands of pages. And the parties mutually agreed, or the court, I guess, said that there could be like a rolling release of records. Okay, usually what happens, and I've done this myself when I served as the right to know officer for the OOR, is we reached an agreement where we would release certain records every week. Okay, we just did not have the manpower for the size of the response to get everything out in a timely manner. So I had a phone conversation with the attorney who was part of the requester team and said, look, this is what we can do. Will you agree to this? Okay, so we had a side agreement that said we'll release a certain percentage of records every Friday. And they worked with us on it and everything worked great. Many agencies will do that. Okay, but there's the only case law that I could point you to that may come close to what you're asking is, and you'll find this on our website, is the State System of Higher Education versus ASPUF, and it's their professors union. And it had to do with the release of budget documents for all of the state universities as they were going into contract negotiations. And I think this was probably 5 or 6 years ago now, but it's out there. You'll find it. I'm sure it's exciting reading. Okay, but yeah, good question. That one hasn't come up in quite some time. All right, moving on. We're running behind here, folks, but had some good questions. Okay, so let's say you're denying a request. There is a format for a denial letter that you should follow. First thing, describe the records that the person is asking for. Why would you do that? Well, maybe their request is a little vague. You know, they're not an attorney, but they play one on TV. So you put, these are the records we think you are requesting. You more or less frame the issue. And then you give the legal and factual grounds for the denial. Remember, the arrow is the person legally responsible for responding to the request. This is also where the rubber hits the road, where the agency is meeting its legal burden for proving why these records should not be released into the public domain. So you're referring to one of those 30 exemptions. You're referring to one of those confidentiality laws that says we're not allowed to give these records out. Okay. And then you put the contact information for the arrow. Again, this is the person who bears the legal responsibility for doing so, and how I get a hold of them if I have any questions. Then you put the date of the response. And this is important because the appeal window suddenly kicks in, and we'll be talking about that. And then the procedure for filing an appeal with the applicable appeals office. Usually, in 95% of the cases, it's going to be that the person has 15 business days to file an appeal with the Pennsylvania Office of Open Records. Okay, and it's the Office of Open Records business days, and they follow even though they're an independent agency, they follow the state's holiday calendar. So you do that, for the most part, you'll be on solid footing. But that's the recourse that the person has, and it needs to be communicated to them when you issue your denial letter. Remember what I said, no surprises. Okay, so someone files an appeal. Typically, they do it on the OOR's website, because now the website is tied into the docketing system, and you can file an appeal online. It's easy peasy. I'm told it takes about 20 minutes, if that. And so they do that, and we look for 4 elements when an appeal is filed. We need a copy of the original request. We need a copy of the agency's response, provided they gave one. Then the person needs to give us a statement why they think the records are public and why they think the agency's denial is incorrect. Okay, if any of these 4 elements is missing, we first issue a deficiency order. and we give the person like 2 days to correct the deficiency, okay? Make it right. If they fail to do so, we dismiss the appeal, okay? It's kicked out. In about a third, believe it or not, about a third of appeals that we receive here are dismissed. But let's say all 4 elements are now present. The appeal gets docketed. And I need to explain this because this may be the most important slide you'll see here this morning. When a case gets docketed, it gets assigned a number, it gets assigned to an appeals officer, and we issue a notice of appeal. This goes out to the person filing the appeal, and it goes out to the agency open records officer that we have on file. Now, if you're here today and you are an ARROW or someone responsible for right to know requests for your agencies, listen closely. If you receive a notice of appeal, run, do not walk to your solicitor and let them know that you have this appeal. Everything I've been discussing up to this point, I would describe as administrative in nature. Once we receive an appeal, the Office of Open Records is designated by the Supreme Court of Pennsylvania as an independent quasi-judicial tribunal. Okay, that's a mouthful, but basically they're saying we are a court. And what this means for you is that your solicitor is the person responsible for addressing the court, not the agency open records officer. Do not attempt to respond to an appeal on your own. Even if it's for a record that you don't have and you just want to give us a heads up, hey, we don't even have this record, okay? It might make sense in your mind, but believe it or not, that is not acceptable to the Office of Open Records. And it's because when we deal with higher level courts, they require certain forms, certain format, certain language to be used. Believe it or not, for that example, the solicitor needs to submit an affidavit attesting to the fact that the agency is not in possession of the records that are being requested, and it needs to be signed, sealed, and everything. Okay, that is only acceptable to the Office of Open Records, not your good faith effort to let us know we don't have this. Okay, that is not acceptable. So that's why your solicitor needs to be in the loop and needs to be the person responsible for responding to these appeals. Okay, do not attempt to respond to appeals on your own. All right, so the product of an appeal is a document known as a final determination. These are legally binding orders coming out of our office that carry the same weight of law as if your county court of common pleas were ruling on it. Issued within 30 days of receiving the appeal, and they are available on our website, or if you have access to one of the legal services, you'll find them out there. You know, if you have the docket number, you can usually Google it and they'll come up because quite a few law firms will copy our final determinations. Believe it or not, it's in excess of 30,000 decisions. They're all available on our website in a searchable database. You could search on your municipality, you could search on your name, you could search on a particular legal issue, you could put in a random text string and see whether or not we've ever ruled on whatever subject you're curious about. Okay, again, on our website. There is the option of mediation. Just real quick, I'll say that if both parties agree to mediation, we have trained mediators on staff who will take over the case. And sometimes it's just a matter of getting everybody together on a conference call and having a discussion. And they're able to agree on what can and can't be released. Everybody's happy and the issue goes away. If they can't agree, well, then it goes back into the normal process and the final determination gets issued. Our decisions can be appealed. Okay, for a local agency, it goes to your county court of common pleas. For a state agency, it goes to the Pennsylvania Commonwealth Court. And the appeal has to be filed within 30 days of us issuing our decision. The Office of Open Records is not a party to the appeal. We are a lower level court, okay? But you have to notify us that you're filing the appeal with yeah, they pay me to talk, with whichever court you're dealing with. And we will do one of three things. We'll either just monitor the case, we may file briefs in order to educate the judge on the right to know process, or if it's believed to be an important point of law, we may request an appearance before the court, okay? But you need to let us know if you disagree with our decision and you're taking it further up the appeal chain. Okay, so we've made it through, despite the fire alarm and everything else and the good questions, to the end of the presentation. If you have any further questions, now's the time to get them in. But in the meantime, I'm going to tell you about our website. Okay, you've heard me say it before. This is the best government website you will ever encounter. Okay, all kinds of resources out there for the public, for agencies, for police departments and the like on the right to know law and the Pennsylvania Sunshine Act, which governs open meetings. Information about training, like the fact that the webinar is here today. We've got the webinar schedule out there and any other trainings that we're conducting. Questions popped up. Okay, right, New Cumberland Borough. When receiving a right to know request, is it only applicable when a formal application is completed? Or for example, if we received an email? Okay, that's a great question. And it's, yeah, your final sentence is spot on. It's up to the agency that you have discretion as to how you want to receive right to know requests. You can require that the request be on either your form or the state form. So you can, respond back with a blank copy and say, please fill this out, and then we'll be able to process it once we receive it. Now, our office, we will accept an email request. As a matter of fact, we have, and this is somewhat of a joke around here, we have accepted right to know requests that were submitted on the back of a napkin. Okay, now when it comes to appeals, we require 8.5 by 11 or electronic, but right to know requests, our office will accept an email. But if your agency wants to have that local requirement that the request must be submitted on our form or the state form, you can do that. Okay, good question. I'm glad you brought that up. Okay, any other questions, folks? Get them in now because I'm wrapping this up. Now, if you are a true geek about government transparency, you can subscribe to our Twitter feed. And every morning at 7 a.m., we will wake you up with all the news that's fit to print that day on what's going on in the world of government transparency. Any decisions that our office has issued, any court cases that came out, any training opportunities, any news headlines, whatever, okay? It's part of our Twitter feed, and we'll put it out there for you. Now, if I end this webinar and suddenly a question comes up, the number's on the screen. Please feel free to reach out to our office. We are here to answer your questions and we'll help you out. What is the average turnaround time from your office if I submitted a right to know request question through the website? Okay. Usually it's 5 business days. We're usually able, like if you submitted a right to know request for a record that the Office of Open Records has. Okay, remember, we only have records that are related to the Office of Open Records. Don't submit a right to know request to our office for something for another municipality because we won't have that. But if you're looking for like, I would like a copy of your annual report. Okay, we'll get that out to you within 5 business days. All right. When you stated that only the response, oh my gosh, questions are popping in here and are rolling off my screen. Let me get back here. Okay, but that's okay. When you stated that only the response is due by the 5 business 30 days, is that only when payment is due? No, no. If you're denying a request, if you're saying that these records are not public, you're still obligated to get that response out within the 5 business day or the 30 calendar day window. Okay, the response, whether you're granting or not. Okay, your Twitter feed isn't available unless someone has a Twitter account. Yeah, it takes you to a login screen. Yeah, you have to have a Twitter account. Sorry I didn't clarify that. I have one and I never use it. Okay. No, I had a question about releasing information and emailed your office. Okay, well, if it was a right to know request, you need to say that it's, and I should have clarified that. You need to say that it's a right to know request in order for the right to know process to kick in. If you just emailed our office, I'm surprised no one got back to you. And I would follow up on that. I would follow up on that. Okay, and then moving on here is the detailed real estate tax collector's monthly report subject to right to know request. Okay, Mary, that's a good question. When we used to have the live training that lasted 3 hours, I covered this, but let's talk about it. Under Pennsylvania law, tax collectors are not subject to the right to know law. So the real estate tax collector's monthly report, it depends. A lot of tax collectors don't provide that report to the municipality. If I want a copy of that report, I would go to the municipality and not the tax collector, because tax collectors are not subject to the right to know law. But if they have provided the report to the municipality is obligated to provide it to me. Now, if the tax collector has not provided the report to the municipality, and I go to the municipality and they don't have it, they're not obligated to go to the tax collector to get it. You understand how that works? It's only if the municipality has the report in their possession, then they must provide it. The tax collector doesn't need to provide it, and the municipality doesn't need to go to the tax collector if they don't have it. Okay, that's how that all works. Okay, are applications for a job posting public information? Yes, for the most part. It would be difficult. I mean, there are internal postings that some agencies have. I can't think of anything that would be sensitive that would keep that from being posted, because the job requirements would still apply. I mean, the fact that it would be made public doesn't change anything. So yeah, I'm going to say, Walt, unless there's something really unusual about the job posting, if it's posted even internally, it's still a public record. Okay. Yeah. Thinking out loud here. Okay. Any other questions, folks? We've gone well over an hour, but that's okay. I'm happy to continue answering your questions. All right. Well, like I said, if something comes up, please feel free to reach out to the office, and hopefully your emails won't get lost and people will get back to you. For any records that we have, you can file a right to know request, but remember, we only have those records that are reflect what the Office of Open Records does. We receive a lot of right to know requests from people who think we are a repository for every record in the state of Pennsylvania, whether it be state government or local government. We're not, okay? We don't have this big warehouse filled with your papers. We only have our own records. And fortunately, most of those are electronic, so we can turn around pretty quick. Okay, I think we're done. I'm going to end the webinar, but I want to thank you for your participation today. We had a good crowd, a lot of good questions, a couple that I haven't seen in years that nevertheless still come up. So have a good rest of the day, folks, and hopefully we'll see you at another one of our webinars. Take care.